There's been a lot of talk lately about how colleges and universities in the United States deal with rape, particularly how they occasionally cover up reports of sexual assault and sometimes give perpetrators a slap on the wrist. In fact, according to the U.S. Department of Education, there are currently 97 colleges that are under investigation for mishandling sexual assault cases. The reason why I'm bringing it up now, though, is because I've just discovered a horrible loophole in the law that allows colleges to violate students' medical privacy. And in fact, a college recently did this in order to defend themselves against a rape victim who was suing them for mishandling her case. Katie Rose Guest-Pryal recently wrote up her findings for the Chronicle of Higher Education. She found a case at the University of Oregon in which a woman was gang raped by 3 men. She reported it to the university. It happened on campus, and the men were students. She then also went to the university for therapy sessions so she could start to get over the trauma of having been raped. The university did eventually punish the male students and kick them out of school, but not before their basketball season ended. The woman sued the university for mishandling the case, and the university, in its defense, went to her therapist and demanded that they turn over the notes from her therapy sessions. The therapists refused, but they were threatened with being fired and eventually did have to turn over the information against their better judgment. Normally in the U.S., this would be a clear-cut illegal move because in the U.S., patients are protected by a thing called the Health Insurance Portability and Accountability Act. And it protects patients' medical records and makes sure that they can't be released without the patient's consent. There are some cases in which this can happen without their consent. For instance, if a patient is suing a doctor for medical malpractice, their records as it pertains to that doctor could become court evidence. But that's not what was happening in this case. In this case, the woman's doctors were and remain on her side. But what Pryal discovered is that the university was in fact acting legally thanks to a loophole in the law provided by a thing called the Family Educational Rights and Privacy Act, which is the federal law that protects the privacy of students' education records. And according to that law, if a student receives medical help on the campus through the university, then their medical records aren't considered medical records. Their medical records are now considered academic records. And as such, they fall under this new act, which doesn't have anywhere near the same protections for privacy that HIPAA has. In other words, if you value your privacy, then you shouldn't use university-provided healthcare because your medical records aren't actually your own, and things like your therapy sessions could be used against you. The unfortunate part is that many students don't really have any other option. For a lot of students in the United States, healthcare is extremely expensive, and university-funded healthcare might be the only thing that they can afford. In that case, if they're raped, they're going to have to go off campus somewhere and try to find a therapy session that can be done on a sliding scale. Some places will do things like that for free, but it's a lot more difficult for them to access. As Pryal mentions in her article for the Chronicle, really the only solution here is to ask the Department of Education to fix this loophole and protect students' medical privacy. I'm not going to be holding my breath.